Good afternoon.
Good afternoon.
Okay, I saw we have some technical issues. There were some email failures. Some of the emails came back. Let me tell you who came back. We had errors for quite a few people. Who didn't get the handouts?
I didn't get the handout.
Okay, hold on. I think what I have to do is not use your work email. So let me do a reply all, and let's see how I can get this to. Okay, give me another hold on. No, I can't use a reply all. Hold on. I think I just need to do a full.
Is this for the manual? Because I know you said that you were going to give us a printout of the manual.
Yeah, the manual, the office should have called you. It was ready when I went there.
Oh, I didn't know. No one called me.
Yeah.
Them tomorrow.
Yeah, it was ready.
The other stuff that was sent, you talking about the tax.
No, I sent that one to you, and then there were some cases. Remember, I told you all there are some cases.
The cases, are you referencing?
Yeah. Case.
The one with the mortgages from Arak Homes?
Yes.
All right, I got those.
Okay.
Good evening. All of us from Family Guardian, we just got ours today because he
okay.
said
Yeah,
he got a personal email address from us.
Yeah, better send your personal email because I had sent it earlier on the weekend and it all came back. So then I had to wait for Mr. Pratt to send it. Okay. So let's get started. I know it's not our normal day, but to make up for the holiday. Now I just sent you all another case. Tell me if you got it, because I got failure notices again. Let me know if you got it. It's Belitza Marling Silver and Replay Destinations Bahamas.
No, ma'am.
No, oh God, I gotta send that later to them. These are just not. I don't know.
Sorry, Janique, you said you got the first set of cases?
It was sent, yes, the personal email. He called, he said he got your personal address. It's bouncing back from our work address. So if we try to send anything like that to the Family Guardian email, it's gonna bounce back. So that's with our private email. But I think the mutual got is also at a personal email address. You didn't get yours?
That's from Pratt?
Yeah.
Yeah.
Okay, yes, I see it, okay.
Okay, you got it. Okay.
Yeah.
That is now, I didn't get.
The one just now, I would have sent a link.
What?
Okay.
first you're gonna have to use our personal. If you're sending it to Family Guardian, well, I don't have access to that, but it's bouncing back. We'll have to use my hotmail address.
So you all give your personal email addresses to Mr. Pratt?
I sent my personal email address to him when I realized there was a problem.
Okay,
So yes, he does have
Alright.
it.
so I'll get it from him. So the ones that I have to send for next week's class, I can do it myself.
Ms. Archer, the Butler versus Pratt is what you just sent, the link.
Yes,
Okay, I got the link.
okay. So I'm thinking that since you all got it late, next class we'll look at the petition of Simon Rodan, because that one is kind of long. But I want you to have the opportunity to read it. And next class, we will look at Walker and Lindborg. That one is also kind of long, 23 pages. And to get started tonight, so you can get familiar with reading these cases, we'll look at Raleigh, Butler Senior, and McDonald. And then we'll also look at the one that I just sent, Philip Gordon Butler and Wendell Pratt. So let's start with Raleigh Butler Senior. Who read that? Anyone had the opportunity to read that?
I'm not seeing that, Ms. Archer.
You didn't see it in the 4 documents that came attached in the email?
Mm,
Yes, I got it. Like we just got it today, so I honestly didn't have a chance to look at it. We just got that.
Okay, it's not too long. That's why I say we'll do this one first and then the next one, because they're short.
Okay, let me look again.
Alicia, what's your personal email? Was it
Tashia, TIS,
TIF?
CHIA
Hmm.
at Hotmail.
TISCHIA@hotmail.com.
Yes, ma'am.
Okay, all right, let me hit send. We should get the whole chain. Okay, tell me if you have it. It's okay, so let's get started. I need a volunteer for next class for Simon Rodan, one for Walker, and another one for Arawak Holmes. Who wants to give a summary next week?
I'll do Arak Holmes and Dennis Dean.
Okay, all right.
And that's a summary you said, right?
Just a summary. Who wants to do the Walker and Lindborg? Alicia? Alicia went quiet.
Sorry, you called my name, sorry?
Yes, you want to do Walker and Lindbergh next week?
Okay.
Okay. And a volunteer for Simon Rodan?
I could volunteer.
Simon, okay. All right, and then I'm going to send probably 1 or 2 more. And then I'll just assign, I'll just say whoever was left, those will be the ones who will present those. So let's look at Raleigh Butler Senior. So this is a matter out of Rumpke. And if you have the opportunity, you can go on the internet and you can read this saga, as they call it, the Effie Knowles saga out of Rumpke. Anyone familiar with that? This is a story that goes on and on and on and goes way back. Anyone familiar with it?
No, ma'am.
No?
No, ma'am.
Oh my
Oh.
Lord.
What's it called?
The Effie Knowles saga.
Oh, no, ma'am.
Because you know, a lot of properties are sold on the out islands in bulk to foreigners. And this was a very hot topic in the newspapers. Trying to get this to, okay. Okay, just give me 1 second. Let me go. I'm trying to go back. And it won't allow me to go back. I have to search it again to see if I could find it. Yep, I found it. All right. I'm gonna send you copy. Alicia, you may not get it again. Send it to Alicia first. Why is it doing this? I noticed the internet last night was not working properly. Okay, let's see if it goes now. Paste. Okay. Alicia, you should have it. Now let me send it to everybody else.
Yes, I got it.
Okay. Now I'm gonna send it to everybody else. Okay, everybody else should have gotten it. So this matter concerns a company called Island Acquisitions Limited, along with the 2 McDonald's and Mr. Jorge Diaz Cueto. So they were constrained, they themselves or anyone who worked with them, along with the company, and they were restrained in terms of selling or advertising for sale, or subdividing or trespassing, interfering or excavating or dealing with these tracts of land in Rumpke. And the reason for that was that the court wanted to investigate who had good title to this property. And it said it was pursuant to the Quieting Titles Act. So under the same order, the same Island Acquisition Company, they were given leave to discharge the injunction, or given the plaintiff 2 days notice, because they wanted the injunction lifted so they could go ahead and finish subdivide the property. So for certain reasons, the court wasn't able to hear the application until late in 2006. And of course, the ruling also was late. So the court apologized for that. So Island Acquisition, they contend that they had good and marketable title based on both documentary and possessory title. And it accepted that the land the Fraser tract was originally conveyed to the predecessor in title of the Butler, Raleigh Butler Sr., as a tenants in common. And they also said that any interest by Raleigh Butler and his family was extinguished by adverse possession under the Limitation Act. So island acquisition title begins with what they call a warranty deed. And this warranty deed was dated June 1st, 1964. And it was from Beatrice Knowles, Wyden, Laura Knowles Roberts, and William Knowles. And they all were said to be devisees under the will of the late Percival Dorset. So when they say devisees, they mean that under the will, the testator would have given this property to these three persons. They say, unfortunately, neither the will or the grant of probate of the will of the said Mr. Dorset was produced. And then also in the schedule of the warranty, the claim of the property in Rumpke by the grantors in the warranty deed was based on possession of the property by Mr. Dorset from 1897. So following the grant of the warranty, the island acquisition alleged that the late Effie Knowles exercised acts of dominion and entered into actual possession of the property. And one of these acts of dominion was settled as a lease from the late Mrs. Knowles to Rumpke Development Company in 1967. So here the judge says that the document is very interesting, as it clearly shows that the parties were not convinced of the good title now being touted by island acquisition. It says, the lease says, whereas it is necessary and desirable that appropriate proceedings be instituted to quiet title to said real property in order that it may be made readily marketable. And in this connection, it is necessary that field surveys and inspections be made. So you could tell even from the lease document itself that the property didn't have a clear title. The other paragraph 5 says the grantee will proceed with diligence to survey, plot, initiate, and prosecute an action to quiet title to all of the property indicated on the attached plot, or so much thereof as may prove to be expedient in light of conflicting claims. So from the outset, they knew that there were conflicting claims on the property. So island acquisition, along with the defendant, which is McDonald, they said that island acquisition was a purchaser for value without notice of any claim by the plaintiff. All that means in legal terms was that he was not aware that anybody else had ownership of the property. But as the document, the lease document reveals, that obviously there was some conflicting claims, because otherwise the lease would not have said that these things had to be done. Now, on the opposite side, you had Raleigh Butler Sr. And what he did was he produced evidence by way of documents and of course affidavits to support his claim that he had inherited at least a portion of the land, the subject of all of this dispute, and that he represented the interests of other owners, which probably were his family members. The documents on their face show a clear line of title from the conveyance to the first Myla Butler and John Culmer to Raleigh Butler Sr. and other members of the Butler family. So you see the difference now. When you're talking about having a good and marketable title, it all comes down to what documents you can produce to show that you have not only documentary possession, but also you have possessory title to that property. So if you look at what he is presenting to the court, he is saying he has a clear title from the conveyance to the first Myla Butler and John Culmer, to himself and other members of his family. And then he's also produced affidavits, which actually provided evidence that the occupation of the land by the Butler family took place from the time of the conveyance to the present time that they are in court. So it was clear that there are issues to be tried between the two parties. Any questions so far? Yes, no?
I have a question.
Go
When
ahead.
it comes to our exams, will we be quoting these case studies?
Now, when you say quoting, what do you mean?
Like-
Name or?
Like you may ask us a
it.
question from this particular case study, or you may draw a question and then ask us which case study best represent that question or whatever the case may be.
Okay, now, first, I won't ask you which case study best represents. I'll probably give you a scenario with an issue, something that happened. So let's take this one where it's a dispute between two parties, both claiming they have title to the property. If you would have read your cases, you would have known based upon the 2 or 3 for that chapter that the best case that aligns with the scenario that I give you is this case. So you don't have to remember that the case was named Riley Butler and McDonald. You could just say in a case or in a similar case.
Okay,
Right. So what you really need to learn is you need to read the cases, and just like how you're going to do to present, you do a summary of the cases, and that's how you begin to remember. When it's time for the final exam, I normally would tell you which cases you need to focus on. So I won't leave you and say, okay, we did 4 cases in chapter 1, 5 in chapter 2, 6 in chapter 3, 2 in chapter thingam, and just leave you blind. I will tell you which ones to focus on.
okay, great.
Yeah. So right now it's just a part of reading it and learning and understanding and asking questions as you go.
Hi, Ms. Archer.
Go ahead.
Just to piggyback off of her question she would have asked just now. When it
Mhm.
comes to the passing grade and passing marks for this class, I know we have a midterm and we have the final exam. Would the midterm exam, would the grades be amounted for any marks towards final, or is it just based on the final exam that we would be looking to pass this course?
No, it's midterm and final.
My midterm and final? Okay, thanks.
Yeah, that's why the first class I asked if you wanted a midterm. The normal way is just one exam at the end.
Okay,
Okay, and I realize it is a lot of information.
all right.
Even though I normally narrow it down by telling you what's coming on exam, students still have difficulty. So I decided for this class here, I would do a midterm and then do a final. So they go together.
All right.
There's no need to be afraid. You all already worrying about exams?
There's a lot of information.
Very true.
Yes, I know it's a lot of information. And I try to make it more real by going through the cases so you can see what's happening in the courts when it comes to land. Because it's not as simple as a lot of people think. And whenever you go to court, you have to have documentation to support your allegations. or documentation to support that you actually own this piece of land.
Ms. Archer, you wouldn't be able to, I mean, is it possible to do like PowerPoint presentations or slides that so we can see summaries that you're asking for as an example or something we can look at during the classes, like how you're presenting now? So like how you're going through this particular case,
Mhm.
maybe, so that we can have examples and read along with you and we can have an idea. I'm a lot visual. I'm sorry.
Okay.
When it comes to learning,
Mhm. That's
I
fine.
think it may help in terms of us, if we can have like a PowerPoint slide to summarize some of the cases that you're reading through, even though you would have sent it just in an email based on what you would provide in a presentation, we would know this is basically what you're looking for.
Okay. Okay.
And we could use that as a help in terms of study guide as well.
Okay. All right. Understood.
Okay.
I'll make a note. Mhm. Any more comments, questions, suggestions? Don't go quiet on me now. No?
No, I don't have any.
Okay. So the third defendant, who's Island Acquisition, the company, they are arguing that they want that injunction lifted. And everybody knows what an injunction is, correct? Yes? So they're saying that Island Acquisition is saying that they're the rightful owners of this property because they had no notice that someone else had title to this property. And their evidence to say that they purchased this property without any notice of ownership is an affidavit that was prepared by Mr. Maxwell Turner. So they allege that Mr. Butler and his predecessors in title were dispossessed, or they actually abandoned possession of that land. And that happened by Effie Knowles and other predecessors to the title. Then they're also saying, and they're also arguing, the Island Acquisition is that they had expended monies in preparing the land for subdivision. They already had the tractors on the property and all of that. And then of course the court granted an injunction. So everything has stopped. They then threw into that whole equation that because this project has stopped, of course, the people on Rumpke don't have any jobs. But they were not able to show to the court that they had obtained approval to actually create this subdivision and to carry on this work on Rumpke. So what they tried to do with the affidavit from Mr. Turner was they wanted to get compensation for the expenses that would have occurred because they had to stop. And the injunction caused their whole project to actually stall, and that means that they were losing money. So even though the Butler family themselves may not wanted a subdivision, the question now comes to whether or not how you're going to use the land and whether or not it's going to be advantageous to which party or disadvantageous to which party. So the judge is saying that if you look at the picture as a whole, several of the lots have already been sold. And you also have to look at not just a dispute between the Butler and Island Acquisition, but you also have to look at the reputation of the Bahamas, because these properties have been sold to foreigners. And based upon that, the judge felt that he should not lift the injunction, because they had to come to the decision as to who rightfully owned this property, who had good and marketable title, because both sides are claiming that they have title to the property. So if you go to that article that I sent to you, Land Wars Continue on Rumpke, this was a very long saga. And after class, you can sit and you can read it and you can see what goes on in a fight for a piece of land. And you know that Rumpke is very, very small. So if you go way down and let me see, almost to the middle, where the paragraph begins, Island Acquisitions, they sought to have the injunction dismissed, but Justice Jeannie Thompson denied it. Her ruling states that the documents produced by Raleigh Butler Sr. on their face show a clear line of title from the conveyance to the first Butler and Culmer to the plaintiffs and other members of the Butler family. Because remember now, what did Island Acquisition produce? Island Acquisition produced for them an actual lease, with the lease going back, but not actually a conveyance. So the issue is good and marketable title. And remember when we started, we saying you always have to go back to that root title, because that's the only document where you can say that you actually own this interest in that land. Any comments?
No, ma'am.
Everybody's clear on that?
Yes.
Yes, ma'am.
Oh, this is wonderful. I like my studious students. All right, now go to the link for the next one. I'll give you a few minutes to read that, and then after that, we'll go into the chapter. Chapter 2. Give you a few minutes, it's only 4 pages. This is the Butler versus Pratt.
Ms. Archer, I don't have that particular link.
You don't, and I sent it.
No,
You don't?
no, ma'am.
Me either. This, you said that you would have to get the addresses from the gentleman.
Miguel.
Pratt?
Pratt.
Okay, let me just do a new email. And give me your emails now so I can put them in. Tell me.
It's Demetria C.
Hold on. DEMETRI.
TIA.
Hold on. This machine is doing its own thing. DEM. Demetria Cooper.
Demetria C79 @gmail. The family guardian one doesn't come through.
Yeah, that's the family guardian one is popping up. That's why I had to stop. So Demetria79@gmail.com.
Demetria C79.
Okay, see. Oh, come on, machine. Okay, next one. You're the only one who didn't get it?
Sorry, no, it's jturnquest@hotmail.com.
Next. Anybody else?
I received the link.
Okay, all right. So tell me if you get it now. Dimitri, you got it?
Nothing yet.
What? I can see right now. It should, you should. I don't have a failed message.
Sorry, Ms. Audra, which case study is this again?
This is, oh, where did it disappear to? This is
Butler versus
Gordon Butler and Wendell Pratt.
Okay, thank you.
Okay.
I haven't gotten it either.
What happened now? Why?
Ms. Arthur, you can't share your screening.
I'm on, no, I don't have it on there. I'm on
Oh,
my,
okay.
have it on the tablet.
Oh, okay.
But I don't understand why you're not getting it though.
You have our right email address? I don't know.
Okay, let me read it off to you so you could see if you could find it. It's, just do a Google search. Put in Philip Gordon Butler and Wendell Pratt plus Supreme Court, Bahamas. It should come up. Got it?
Butler Pratt's ruling. I found a PDF. Is that what you're meaning?
It should say at the very top, Commonwealth of the Bahamas in the Supreme Court,
Uh-huh.
Gordon
And-
Butler, Wendell Pratt.
Gordon Butler and Weldon Pratt. Yeah.
Yes, okay, that. It's only 4 pages.
Yes, it is.
Okay, very
I have
short.
it.
Okay, get a quick read and then we'll discuss that one. Whoever's finished first and want to try and summarize what they think was happening, feel free. Anybody want to try or still reading?
So reading.
Okay, all right. Quite interesting, right?
Yes.
Yeah, because she said in her will that he could remain until he remarries.
But he's not moving out.
And he did remarry.
He remarried.
His argument is that he has equitable
Equitable rights.
interest in the property because
Yeah.
after her death, he still maintained the property, he still paid the bills, he still paid mortgage. So he feels he still has rights to this property because of his equitable rights.
But he doesn't.
Why is that?
Even though he paid into
Because-
it, whose name was on the mortgage and who was the rightful owner of the property?
Mhm.
I could say I put gas in my mommy car, but that ain't my car.
And he's referring to it as the marital home, but isn't his wife deceased?
Right.
I think we have to take in consideration tenancy in common where the rights do not transfer to the survivorship or something like that.
Yeah.
She actually divides her legal interest. She gave it to her son.
Exactly.
So it's
So-
also the fee simple absolute.
But he's arguing now. We gotta get someone who argues on the husband's side, who believes the husband. Oh,
That's outside.
The husband wrong.
he claimed he paid the entire funeral expenses of his wife.
He clean,
What
and
did
the
that have to do with
doctor's
the house?
hospital is following him for outstanding medical bills.
His
Which-
father could pay for his wife's funeral.
But what did the court say to him?
I get that far, yeah.
Oh, you ain't
That,
gonna get then. Let me wait.
with those items, I think he's the interest that he's claiming or wanting the equitable rights or interest in the home has nothing to do with the fact that it's a marital home or the bills that he would have paid. I think that's something it's two different things. where he should be placing or looking for recourse should not be by way of him remaining in the home.
Mm-hmm.
It should be with the executors. Am I saying that right? If I read that right?
Uh-huh, yeah.
As opposed to him wanting the interest or him remaining in the home. It can't come by way of the home because she said that she gave her legal interest to her son and he could have remained in the home as long as he didn't remarry or until he remarries.
But look at it like this. Remember, from our first class, land has two interests,
Uh-huh.
interest and legal interest.
Right.
And he is fighting for his equitable interest
Equitable interest.
because of what he has done. Now, let's put aside that she was dead. Let's just say they were filing for divorce. If they were in a divorce, he can fight for his equitable interest. If she was still living,
She would have to pay him out.
she would have to pay him out, yes. But now she is deceased.
So her interest was put into a will and she designed as to who she wanted that to go to.
Yes, better caveat. What did the caveat say?
Yeah.
But he can't only until he remarries.
Right, he could stay there for life if he's single
If he's single.
or until he remarries. So once he remarries, he cannot remain in the house anymore.
He can remain in the house.
Right,
So-
so that means that when she says he could stay there for life, he can stay there for life under his equitable interest in it being the marital home.
Mm-hmm.
Would have been the widower of Mrs. Pratt. But once he got married, his status changed.
That's no longer their marital home.
No,
His interest expired on the remarriage of the defendant.
so in order for him to make this claim that he had an interest in the home because of,
done it
yeah, all these things he had done, he should have done it when?
before he remarried. If he
No.
wanted to claim his equitable interest,
Uh-huh.
could he have done it before he remarried?
He should have done it before the probate was granted.
Ah, before the probate was granted. Okay.
'Cause
He
the
should
probate's
remember now,
definitely-
when a person dies, right? You notice in the paper there's an ad.
Mhm.
You notice that paper in the ad say in their state of so-and-so.
So, yeah.
Are any creditors?
Mm-hmm.
He should have put in his claim then.
Okay.
Creditor.
Which he,
Hello?
Hi.
yeah, yes.
Oh,
No, I think someone dropped off. They probably coming back in. So if you look at paragraph 13, the judge says, the time for making such claims would have been prior to the sealing of the grant by way of a caveat. A right that the husband neglects to exercise. So everything that comes on timing when it comes to law.
so that meant that he agreed to the terms of the will by accepting the caveat.
No, no, no.
The-
The caveat means that when they would have placed the ad in the paper asking if there were any creditors
Oh,
Because- wanted to be reimbursed, he had to go and put in a caveat. That's an application where
oh,
he said, I paid these bills for her while she was in hospital. Here are the bills.
okay, now I understand.
He should have done that. So when the probate court would have looked at her estate, the first thing they do is by law, it says you have to pay off all the debts of the deceased. The court would have made a decision based upon the invoices that he would have brought in, whether or not those were just bills to pay against her estate. And they would have been paid before any funds are distributed to the beneficiaries. And if that meant that the amount that the poor court would have granted to the husband was, I don't know, what it could have been. Let's say the hospital bill was 30,000 and she didn't have 30,000 in cash or in stocks or investment. The house would have had to go up for sale.
So they wouldn't even look at the fact that that was her husband at the time and he was paying the bills as a husband?
That's what I'm saying. I'm saying the court would make a decision.
Okay, oh,
And-
okay. So it's not clear cut. They would
No.
decide if that's what's gonna happen.
Because then you're moving into the matrimonial side.
Okay,
You see, about love and oneness, and that's a different law. So even when you look at paragraph 13, the case that was presented on his behalf was not the right case. So based upon 16 says, based upon the construction of the will of the deceased, the husband acquired an interest in the deceased property. However, the interest expired when he remarried. So if he was at the very beginning thinking that, guess what? This is how she wrote her will. I paid all this money. He should have entered a caveat. Then they called for all of the creditors, and he didn't do that. So the court gave the son all of the parcel of the land and the house that was on it. And the husband had 45 days to move out.
and
With his-
you said there was another word for caveat?
No,
No?
caveat, no, caveat is where you go to the court and you put in an application to say that I am a creditor.
Oh, application is what I was thinking about. Okay,
Deceased
Okay.
would have, yeah, the deceased would have actually owed me this sum of money. But then, like we say, at that time, the court would have looked at, okay, but you're a husband. What is expected of you in a marriage? And is it over and beyond? And then he'll have to prove how, by expending that amount of money, the state it would have left him in. So say he had used up all of his personal savings and he had nothing left and she left him nothing else. But of course he wanted a new wife. So he must have some money somewhere. So that is another one where he's claiming his equitable interest. So let's go to module 2. So module 2 is talking about purchasing property and the conveyancing process. Now, you notice I sent you a document called Real Estate Transactions and Legislative Amendments. Everybody got that, right?
Yes.
Okay. Now, the difficulty with that document and our notes is that the last time when we did the amendments, which was in 2019, we had made a lot of changes to these same pieces of legislation. Now we're in 2022, they have changed them again. Because you know, these pieces of legislation all have to do with income generation for the government. So they're never static. It's always moving. So they always say that when you purchase land, you know, you always tell your young children that the first thing they do, you try to tell them, don't buy an expensive car. Try and purchase a piece of land. Because they always say that land is an investment. So whenever you're purchasing land, of course, that comes under the Conveyancing and Law of Property Act, 1909. It has not been amended. And of course, everything to do with land law is based on case law as you can see, as we read these, and you see reference is also made to English common law. There are some instances where you see cases may be referred to other Caribbean jurisdiction or other Commonwealth jurisdictions. So the first thing is the preparation of the contract. The sale and purchase of property is initiated by an agreement between the parties, the vendor and the purchaser. The terms of the agreement for sale can be negotiated between the two parties. And that can be done with the assistance of the real estate agent, and of course, an attorney is involved. The next step is the approval of the contract or the agreement for sale. And I would outline the terms and condition of the sale of the property. It'll have the purchase price, the deposit amount, the completion date, which is normally 1 to 3 months. It'll give you the obligations of the vendor, and that is to prove good and marketable title. The undertakings by the attorneys for the vendor and the purchaser. And the consequences if the vendor failed to provide good title, or if the purchaser is not able to obtain financing to complete the purchase of the property within a specified time. So all of that is in the agreement for sale. Next is the deposit, which is normally 10%. The total price is often paid to the vendor's attorney at the time of the execution of the agreement for sale and is held in escrow pending completion of the transaction. Let me stop right there. You know what looks suspicious? Is when you and two persons enter into an agreement for sale and the deposit is paid. And then the vendor starts asking for the deposit to be transferred. What's wrong with that?
Deposit's supposed to be held in escrow for a certain amount of time.
Yeah, and normally, especially if you're dealing with foreigners, it should be for the completion of the transaction.
Yes.
Because in the terms and condition, it could be that if you don't fulfill your part of the bargain, there is a penalty. So if you in turn send out the deposit, then where is your security? So let's talk about deducing title. The execution of the agreement for sale, the vendor provides the receipt of the original or the copies of his title documents. This abstract of title covers a period of time fixed by the contract. So in your mind, go back to our first case, Raleigh Butler and Island Acquisition. What did Island Acquisition bring to say that they had title to this property?
A lease.
They bring a lease and affidavit from Maxwell Turner. So it is commonplace for the vendor to deduce his title before exchange of contracts. This permits the purchaser to satisfy himself as to his acceptability before being contractually bound to buy the property. And this is where a lot of purchasers fall into that trap where they enter into an agreement, they make the deposit without trying first to see whether or not this person has some semblance of a good marketable title. So next step is the investigation of the title. This is where the purchaser's attorney then investigates the title to the property, and they do that by conducting a title search. They also will go to the Supreme Court listing, and they look if there's any previous owners to the property. The purchaser's attorney confirms whether the property has a proper chain of title. So under the Act, a purchaser of land is not entitled to require title to be deduced for a period of more than 30 years. So when you talk about a proper chain of title, the law says that you can go back to 30 years. Once you hit 30 years, you can stop. Or it says you can go to a period extending further back for a grant or leased by the Crown. So say if someone is selling a piece of property and you can see that that property was granted or leased by the Crown 15 years ago, you don't go further than that 15 years. Or you could have a certificate of title granted by the court in accordance with the provisions of the Quieting Titles Act. So you notice in the paper, you'll see these ads where they have a notice, Quieting of Title Act, and they'll actually show you a drawing of the land that the person is seeking to acquire. So the act says that if you're looking for that title and going back, and if that title you see was 2 years ago, and they got a quieting title, you don't go any further. So that's 3 different scenarios for when the purchaser's attorney is investigating the title as to how far they can go. Now, the purchaser's attorney also have to investigate any outstanding real property taxes against the property or any property owners association maintenance fees that are due for condominiums. They have to see if there's any utilities that are actually due. And if there's any application to be made to the investment board for permit or approvals, that also has to be done. Now, the purchase attorney may have some questions or inquiries on the title and any other matters related to the vendor or the vendor's attorney. So after investigating title, any requisitions or possible defects in the title, the purchaser's attorney has to make that known to the vendor or the vendor's attorney. The purchaser's attorney will also reserve the right to raise further requisitions on title. And that depends on what the vendor's attorney responses are to the queries that he has raised, because they may have further investigations that need to take place. So the agreement for sale normally provides for a specified period and is normally 14 days from the receipt of the title documents for requisitions to be made and for the investigation of the title. The purchaser's attorney may raise questions on the requisite government and subdivision approvals. You saw that also in the Raleigh Butler matter, where the courts asked whether or not they had obtained these approvals for these subdivisions, because they were excavating the land, doing all of this development without subdivision approval. Whether there's any outstanding real property tax assessments, utility bills, whether the property has been surveyed, whether there is any easements or right-of-ways or restricted covenants that run with the land. So upon the requisitions on title being satisfactorily answered, the purchaser's attorney will prepare a report on or opinion on the title for the purchaser and or relevant lending institution, as if it's like a person getting a mortgage. So we know historically that these opinions on title have been prepared by attorneys, which in fact did not give a proper chain of title. So a lot of the commercial banks fell into that pool of loans that they had where they didn't have a proper chain of title. So even in your role, you should understand what a chain of title is. So you should be able to take one of those documents and read it and see whether or not the chain has not been broken for the title. The draft conveyance of the property is normally prepared by the vendor's attorney. And of course, it can be reviewed and the requisitions for title and the cost list searches by the purchase attorney or subsequent to any requisitions. The conveyance will include the names and addresses of the parties, any references to earlier title documents. It'll have a detailed description of the property. It'll also state whether there are any restrictive covenants or easements or right-of-way. it'll have a plan of the property and the appropriate affidavits of citizenship and witnesses, and anything else that's specific to the conveyance. So once completed, any amendments are being done and approved, the conveyance is finalized by the vendor's attorney and is executed by the vendor and the purchaser. Of course, by law, because you're dealing with property and under the statute of frauds, the signatures have to be witnessed. A completion statement is prepared by the vendor's attorney, and then the balance of the purchase price is paid by the purchaser's attorney, less the vendor's portion of stamp duty, any apportionment of rates, real property assessments, utilities. So it depends on the agreement that was struck between the two parties. The vendor's attorneys may forward the title document to the purchaser's attorney in escrow, pending the final payment of the purchase price. The legal fees may range from 1.5% to 2.5%, and they're paid on or for completion by the vendor and the purchaser to their individual attorneys. Commissions to real estate agents are also paid at that time. Requests are made to utility companies to return deposits to the vendor, and all utilities and real property tax assessments are placed in the purchaser's name. So once the balance is paid, then the vendor's attorney is subject to the completion statement, is paid. The balance is paid as per the completion statement, and the vendor or his attorney acknowledges receipt of the payment. Then the property transaction is complete. The conveyance with the property with appropriate affidavits and pertinent documents is sent for stamping at the Treasury, and the stamp duty to be paid on a conveyance, which is normally split between the vendor and the purchaser, is based upon the total consideration of the purchase price. Now, if it is a property being purchased by a non-Bahamian, they normally will purchase it through an IBC, an international business company. And the IBC acts as a holding company for that piece of property or whatever asset they're going to put into that company. The property investment vehicle, it allows the investor, the foreign investor, to enjoy anonymity, because then the property holding will be in the name of a company. They'll have limited liability because it is a separate legal entity. They will also have confidentiality. So no one will know the name of the individual that owns the property. So most times people would use this structure for wealth management and asset preservation. So non-Bahamians are required under the International Persons Landholding Act. They have to register their purchase with the Bahamas Investment Authority, and they have to obtain a certificate of registration. Otherwise, they are required a permit from the investment board prior to their purchase. A certificate of registration is not only required for vacant and non-vacant land, but also for condominiums or property under 2 acres that will be used as owner-occupied property. A permit is required by non-Bahamian property owners for the purchase of property, like I said, for 2 or more contiguous acres, to rent out all or a portion of the property, or where the property will be used for commercial purposes. Non-Bahamians have to obtain a permit. Permanent residents also have to register their purchase of real property, whether it's vacant or non-vacant, but they are not required to obtain a permit. A non-Bahamian lender that acquires security on properties in the Bahamas, they have to obtain exchange control approval and also a permit from the investment board. Now, This is the part now that has changed a lot in the last few weeks. Stamp duty. Under the Stamp Act, application for exemption from stamp duty on the acquisition and mortgage of property for first-time owners has decreased from 500,000 to 300,000 or less. So the Stamp Act brought about several changes with regard to stamping documents. Under the Act, the applicable stamp duty will be the stamp duty that is enforced at the date the documents or transaction are presented for stamping, and not the date when the transaction was completed or the document was drafted. Additionally, stamp duty will be paid on the greater amount of the purchase price or the market value. And that will be evidenced by the appraisal. And not just the purchase price consideration mentioned on the document. The Act also extends the definition of mortgage to include any promissory note that is made supplemental to or in connection with a mortgage or a charge. Stamp duty is also required to be paid on a combined consideration where there are property transactions involving a transfer of land and a construction contract. Transfers of property from an individual to a company, all of whose shares are beneficially owned by that individual, has to pay VAT now. Transfers of property from an individual to a trustee of a trust is exempt. So under the Stamp Act, the treasurer may stamp any unstamped or insufficiently stamped instrument after its execution, provided payment of the unpaid stamp duty and a surcharge of 10%, where 6 months or more has elapsed from the date of execution of the document. The Act also allows the treasurer to take into consideration the value of any adjoining property in dispute as to its value, sold within the preceding 12 months in determining the liability for the payment of a stamp duty of a disputed property. The Act also levies a 2.5% stamp duty on the value of a deed of conveyance, assignment, or transfer of real property. And that's normally split 50-50. Additionally, the stamp duty of 2.5% of the value of the interest in real property is levied on a transaction or instrument, which is treated as a transfer of land, which has the effect of transferring an interest in real property by virtue of the transfer of issued shares of the beneficial ownership. Stamp duty of $10 is payable on a deed of rectification or confirmatory conveyance, where stamp duty has been paid on the initial conveyance, and where there is no change in the parties to the conveyance. It's just a clerical error. So where mortgage or transfer of a mortgage, 1% of the amount of the mortgage or the transfer is charged. In instances where there is a transfer of mortgage, the instrument evidencing the satisfaction of the subsitting mortgage and creation of a new mortgage is exempt from payment of stamp duty. Under the Stamp Act, the treasurer may stamp an application for the exemption of stamp duty on any instrument made pursuant to the provisions of the Act. And where approval for the exemption has been previously granted, and where the title document to which the application refers, that is the conveyance and or the mortgage, remains unstamped, subject to the payment of the surcharge and evidence that approval for the exemption has previously been granted. So you know that VAT is at 10%. And The VAT rules allow a purchaser as a VAT registrant to claim input taxes on a supply in accordance with the rule on real estate. So procedurally, with regard to the payment of closing costs, VAT is normally paid to the VAT controller based upon his determination of the VAT to be paid on the property transaction. The VAT controller may request that an appraisal report be submitted that reflects the true market value of the property. If he is unsatisfied with the consideration amount listed on the conveyance. After the payment of VAT, the relevant stamp duty of 2.5% is paid to the public treasury, and the title documents are subsequently submitted to the Registry of Deeds and documents for stamping and recording. Also, under the VAT rules, VAT is charged on professional services, inclusive of the legal services, the appraisals, the title searches, and real estate commissions. First-time homeowners who are exempt from the payment of stamp duty are also exempt from the payment of VAT on property transactions. So let's look at how the government has recently changed the taxes on real property. So look at the handout that I sent. It says in the budget communication presented by the Right Honorable Prime Minister, he communicated his intention to introduce various legislative amendments to the Real Property Tax Act, the Stamp Act, and the Value Added Tax Act. And they all took effect on the 1st of July of this year. So he has redefined what is commercial property, residential property, unimproved property, and value. So commercial property is any property used for business purposes, including any property that falls within the proviso of the definition of residential property. He says residential property is any property that is not owner occupied, that comprises not more than 4 units, that is beneficially owned by Bahamian citizens or a person registered under VAT for the operation of a property as a commercial rental establishment, and that is used solely as a dwelling place. Provided that where a person owns more than 4 dwellings that are not owner occupied, each property shall be classified as a commercial property. So he defines unimproved property is any property on which no improvements have been effected. And this includes properties that are under construction, unless it's occupied or a certificate of occupancy has been issued. It doesn't include properties used to carry on business activity. The value for unimproved property, the average amount over a period that the chief valuation officers of the view allows for a fair determination of the property's value, which a willing seller may expect to realize from a reasonably well-informed buyer if the fee simple of the property is sold on an open market, free from encumbrances or any other burden, charge, or restriction. And then they give the definition of improvements. And that is based on the chief valuation officer's assessment. And then improved property, again, based on the chief valuation officer's assessment. So owner occupied properties. Properties owned by a company may now be classified as owner occupied property, where the beneficial owner of more than 50% of the company's shares occupies the property exclusively as a dwelling on a permanent or seasonal basis. And they have to submit a declaration to the chief valuation officer that that property is occupied by the beneficial owner exclusively as a dwelling house or on a permanent or seasonal basis. Owner occupied properties also is where a person owns more than one property that is used as a residence for the owner. Only one property will be classified as owner occupied property. An owner occupied property is also where a married person with his or her spouse owns separate properties that are used as the matrimonial home or as a residence for either spouse. Only one property will be classified as owner occupied property.
Ms. Astor, I have a question.
Go ahead.
When it comes to this new amendment, a
Mhm.
property that is occupied by the owner, however, the building has units attached to the property, is that considered a commercial property or a residential property?
Okay, so a residential property is any property that comprises not more than 4 units.
Okay, so if they have less than 4 units and the owner occupies the property, is that a residential property?
It appears so.
So if it's a residential property, should you be paying property taxes on it?
But you can find out now how they changed the levels.
Okay.
Because it says here that where you own more than 4 and they are not owner occupied, then they'll be classified as commercial property. So owner occupied property. Exemption is granted to owner occupied properties has increased from 250 to 300,000. The maximum annual cap for owner occupied properties have increased from 60,000 to 120,000. So what are the new rates for owner occupied properties? Up to 300,000, of course, is exempt. Between 300 and 500,000 is 0.625% of the value per annum, which was the rate before. And anything over 500,000 is 1% of the value per annum, but subject to a maximum of 120,000 per annum. So that 1% hasn't changed, just the cap. Commercial property, the real property taxes owing on commercial properties valued at over 500,000 has decreased from 2% to 1% per annum for those properties valued at up to 2 million, or 1.5% for those properties valued above 2 million. And I know they were discussing this on the radio about this tax for commercial property. The new rates of real property taxes on commercial properties are now as follows. Up to 500,000 is 0.75% of the value per annum. 500,000 to 2 million is 1%. And anything over 2 million is 1.5%. The new rates for real property taxes on any other property is as follows. If it's Bahamian owned, 1% of the value of the improvements per annum. And if it's non-Bahamian owned, is 1% of the value of improvements plus the amount payable for the unimproved value of the property. And of course, the chief valuation officer, he can combine properties of one owner under one assessment number where the properties are contiguous and used for the same purpose. The owner of property must notify the chief valuation officer within 30 days of receiving subdivision approval or approval to construct a condominium for separate assessment numbers to be assigned for each lot or unit. Now, real property taxes, everybody knows, is due on the 31st of March each year. And surcharges only accrue where taxes are not paid by the 31st of December in any given year. The chief valuation officer may, for reason which appear to him sufficient in a particular case by written notice, postpone the date on or before which any tax is payable. So you normally see it in the newspaper. There's large advertisement advising when taxes should be paid. Where a loan has been repaid on a mortgage property, but the satisfaction has not been stamped in accordance with VAT Act, that mortgage property shall still be deemed to be under a deed of mortgage. And the mortgagee will still be liable to pay the real property taxes on commercial property if taxes remain unpaid in excess of 90 days. So take note of that. Only owner occupied properties.
Ms. Archer, sorry, what you just said, this in the book?
No, this is in the handout what I sent today.
Yes, I trying to find, okay.
You don't see it?
No, I still looking for this handout, because I was
In the
flipping through the
email.
book and I didn't see it, and now I looking through my emails.
In the email. You should have gotten it.
It's real estate transactions, legislative amendments.
Yes.
It was a separate email, Alicia. It didn't come with the case, the different cases.
Let me know, then she can let me know when she finds it.
We would have received it yesterday.
Well, we actually got ours today. Alicia, it was right before, right after the 4 case studies. It came in, it's shortly in between, time in between.
Did this come from Mr. Pratt?
You're right.
Okay. Go ahead, Ms. Archer, keep teaching, don't worry, I don't want to hold it up, go ahead. I'm
Okay.
listening. Go ahead.
Yeah, right. So you heard what I just said about liability of mortgagees in respect of commercial properties.
Yeah,
Okay. So only owner occupied properties which are beneficially owned by Bahamian citizens are exempt from the treasurer's exercise of power of sale. That's the next thing you need to note. So exempted properties.
Ms.
Profit-
Archer, sorry, what is
Mhm.
power of sale? I don't, did we go over that?
What, the power of sale?
Yeah,
We'll get to that later down. This is when the bank exercises its power to sell a property.
okay,
Borrower cannot make the payments
okay.
after
Right.
three consecutive. Yeah, that's the power of sale.
I have a question.
Yeah.
This you were saying with commercial properties and the bank more or less being responsible for paying the real property taxes?
Mhm.
Okay, let me ask you a question. Is the bank legally, I mean, I don't know if I'm straying, responsible for the taxes? Is the bank gonna be, do you actually hold the bank liable if if the person doesn't pay the taxes?
I know, have you noticed in the papers where the banks have put an ad in the paper? Have you noticed that?
No, I haven't.
Yeah, there's been an ad in the paper, reminding persons with mortgages that they are obligated to pay their taxes. Now, I know the commercial banks were pushing back because what the government was trying to do was make them debt collectors of their taxes. And they said they didn't want to do it. But we're at a different point in time where we have a lot of real property tax that is outstanding. And so all parties now have to work together for a common good.
I know
So
what we have started doing is, with our loans, we have started, advising our clients that if they don't pay it, we'll add it to their loan.
Yes.
So,
And then what happens in the end is that if the mortgage payment has to increase and then they can't afford it, then it moves into another bucket whereby it could eventually, if arrangements can be made, eventually it will go up for sale.
So, Ms. Archer, I see that the legislation has, with respect of commercial property, does that mean for residential properties as well? Does the same, rule apply for residential properties? The mortgagee's liability, I mean.
Yeah, you have to pay.
Oh,
So you'd have seen the amnesty period this year. You heard about the amnesty?
I've heard about it, yes.
Okay, so amnesty is where persons, residential properties would go to real property tax. You can actually get if you pay early, you can get a discount. If you're a senior citizen, you can get a discount.
Yeah.
So it is available. And even if your assessment, you think your assessment is too high, you can go in and ask for another valuation. But you have to do it within the time frame stipulated by the government. And they normally advertise, they have a half a page advertisement in the paper when it comes to collection of taxes.
I have
So-
one last question on this, sorry.
oh.
So if it isn't done, so it's a penalty to the mortgagee if they don't take responsibility for it then?
Because don't forget how the very first thing that has to be paid if you sell that property is the taxes.
I was just about to say that. I mean, I feel like the bank, I could see why they want the bank to kind of be responsible because technically when you're paying a mortgage, you don't really own that property yet. As an
Agreed.
individual, it's still the bank's property until it's satisfied and paid off. And so going back to the beginning, when it's marketable, all those taxes and stuff need to be paid. So
Yeah, because don't forget, in the mortgage deed itself, it says that the borrower, the mortgagor, is responsible for paying these taxes. It says it right in there. That's one of your obligations. And so if you don't pay it, then of course now what the bank does is it pays it for you and tax it onto your mortgage. And as it keep tacking it on, what's happening? Your debt is growing higher, your payments are increasing, and then you move into the next step. So a lot of people over the past years who have added on to their houses all went screaming to the Department of Inland Revenue. Because the valuation of their homes had increased and they had to pay real property tax, and they didn't figure that the numbers were going to be that high.
So, Ms. Archer, what happens to the mortgagee if the client satisfies their debt? And they're provided with a satisfaction. They don't have a debt with that institution anymore. Would the
Mhm.
mortgagee still be responsible for collecting the real property tax
No,
or paying the real property tax?
no.
well, I don't know, I don't know if Janine can have audio, but she can chime in on this. I think with the bank, when a mortgage is satisfied, I believe that we actually require the client to bring in a certificate that says there's a zero balance and there's nothing owing before we even provide the satisfaction. So
Yeah, that's all. But after that's done, that's it.
yeah, that's it.
That's it.
Okay.
But getting a mortgage is a huge responsibility. Because not only do you have to pay the mortgage, you have when you look at your obligations in that mortgage deed, you have to upkeep that building. You have to keep that house in a good state of repair. Because remember, you only have an equitable interest until that mortgage is paid off.
Yes, that includes insurance and all.
That's insurance also. And you know, Bahamians do not like to purchase insurance until, of course, something happens. So properties that are owned by religious institutions, non-profit organizations, trade unions, civic organizations, and burial societies are all exempt now. All of them. Now, under the Stamp Act, that was the real property tax. So under the Stamp Act, it says that all references to transfer of land has been removed. So where a transaction comprising the sale of any business will involve the transfer of a land or share in a land owning company. So land owning company was, like I said before, is like an IBC or regular company that was incorporated to hold assets, real estate. That transaction will be subject to VAT. Leases of realty with a term of less than 5 years are also now subject to stamp duty at a rate of 2.5% of the annual rate. The following instruments are now exempt from stamp duty: a lease of realty with a term of 5 years or more, a transfer of crown lease, affidavits, other than affidavits of loss relating to conveyance on which stamp duty or VAT was never paid, any agreement not referred to in the first schedule of the Stamp Act, the declaration of condominium, a grant of right-of-way, a lease of easement, or renunciation or release of dower. All of those are exempt from stamp duty. Now VAT. The collection of VAT on the supply of property, where more than one instrument is executed as part of a collateral to secure the same loan. VAT is chargeable on the applicable rate on only one of the security instruments. And no VAT shall be assessed on any other agreement, instrument, or document delivered simultaneously with the security document, chargeable to VAT. But this only applies where the entire amount of the loan is secured by the instrument chargeable to VAT. And all security documents are submitted simultaneously for stamping. Every instrument for a supply of real property shall, from the 1st of October this year, state the real property tax assessment number in respect of all property to which the instrument relates. It has to be presented to the VAT department within the time prescribed by the VAT rules and not be stamped unless all outstanding real property taxes due to the property to which the instrument relates has been paid. So you see the government is clamping down now on the collection of VAT. So you just don't walk in there with your piece of paper anymore. You must have your real property tax assessment number on all of your properties. Any exemption, permissions, or approvals granted under the Exchange Control Act or the International Persons Landholding Act in respect of the acquisition of real property are now conditional on the payment of VAT within 18 months of becoming due. And if the VAT remains unpaid for that 18 months, the exemption or the permission or the approval would be considered rescinded. But it'll be automatically reinstated once you pay your VAT. So this applies now to foreigners who would purchase, they would get their permission to purchase land, and then they don't pay their VAT. Of course, Bahamian citizens are eligible for a refund on VAT paid in connection with the construction or renovation of a citizen's first home, and the criteria for eligibility will be prescribed in the VAT regulations. So you know they're in the process of, based upon these new amendments, they're in the process of amending the regulations and the VAT rules. So instruments relating to the acquisition of a dwelling for the first time by a Bahamian, where the value doesn't exceed 300,000, they are exempted for supplies of real property. Instruments relating to the vesting of real property in a beneficiary under a trust, they are exempted. Instruments relating to the transfer of real property between two or more companies, where at least 95% of the shares of those companies are owned by the same person, they are exempted. And VAT would only be payable to the extent of a change in beneficial ownership. And any conveyances by way of assent and deeds of assent, they are exempted. So what they've done now is laid out the new rates for supplies of real property. And every deed of conveyance is 10%. There's a 2.5% where the value does not exceed 100,000, 4% if it's not over 300,000, 6% if it doesn't exceed 500,000, 8% if it doesn't exceed 500,000, but doesn't exceed 70,000. And I think that 70 should be 700. And then 9% if it doesn't exceed 700, but not 1 million. And then 10% for anything over 1 million. And it goes on. So you see what the government has done, right? Is tighten the reins on the payment of real property tax and also given some exemptions, especially for residential property. So you know, go ahead.
The VAT on real property tax, saying that this is amended for this year, will this be retroactive for the taxes that were not paid up to this year?
You mean if you have an outstanding tax?
Yes, are they gonna charge VAT going forward, or they're gonna pay it on what's owed?
So you have to wait and see what the amendments to the act and the rules say.
I thought this was the
They
amendment.
haven't sent that out as yet.
Oh, okay.
Yeah. Whether it's retroactive or not. I can find out for next class.
That would be nice.
Okay, that's on outstanding VAT, right?
Yes, yes,
For real property tax.
yes.
Okay, we'll find out. So, you know, in addition to all of this and getting a mortgage and first starting out with purchasing the property, you have to pay for your title search. Their recording fees have to be paid. And of course, each bank has its own service fees for mortgages. So in your notes, you'll see some of the VAT rules where supplies of real property are exempted. So this new legislation revamps all of that. So I know when we did unit 1 last week, someone asked what are leases? And you see the government refers to leases in this new amendment. And I explained to you that lease is a contractual agreement between the landlord and the tenant. And what a lease just does is it sets out the duration of the rental, be it a private property or business space. So a lease could be for short term or it can be long term. But whenever there is a lease, for a lease to be valid, there's certain characteristics that has to be in place. The tenant must have the right to exclusive possession of the premises, which means that when you rent that property to that person should not be interrupted by you knocking on the door or coming into their space. That's what exclusive possession means. There is no defined premises for the lease. It's only a contractual obligation to provide storage for goods with no defined space. The arrangement would be considered a mere lease and not a tenancy. A lease cannot be for an uncertain period, so the period have to be fixed. And a lease must also be created in the proper way. That means if it is a lease to create a legal estate, then the deed has to be written in that way for enforceability and assignability. So there are types of commercial leases. A lease could be granted for a fixed period of a certain duration, and both the commencement and the duration of the term of the lease either has to be certain or be rendered certain before the lease takes effect. So that's one of the key things of a lease. The duration has to be certain. So a lease for a fixed period automatically determines when the fixed period expires on the lease. A yearly lease goes from year to year until it is terminated by a proper notice. You'll notice that when someone has a yearly lease, you'll see it goes year to year to year, and then there's a clause that speaks about when that lease can be terminated. So generally, a yearly lease may be created by implication in instances where a person occupies premises with the owner's consent, particularly in circumstances where tenancy was intended and rent was charged and measured for a year is paid and accepted, unless there is evidence that a different type of tenancy was intended. Monthly, weekly, or other periodic tenancies may also be created in the same way as yearly tenancies. It could be by express agreement or it could be by inference. An inference could be where it depends on the frequency how the person makes a payment. So say if a person has a tenancy and they pay every 2 weeks, then that is their tenancy, bi-monthly. So a tenancy at will is where a tenant, with the consent of the landlord, occupies the premises as a tenant on terms that either party can terminate the tenant at any time. So unless the parties under tenancy at will agree that the tenancy will be rent-free, that landlord is entitled to some compensation for use and occupation of the premises. A tenancy at will terminates when either the landlord or the tenant does any act that is incongruent with the tenancy. So that means that either one of them would give notice. The general provisions of a commercial lease is, in addition to the parties, the premises, the rent, and the duration, the lease should actually specify the rights, the duties, the obligations, the responsibilities of the landlord and the tenant. It could also reference subtenants, because you know some leases do not allow subtenants, some do. And of course, the parties can agree on the usual covenants, like who does repairs, who is going to do cleaning, who's responsible for paying this bill, utilities, who's responsible for paying taxes. The parties to a lease should ensure that certain provisions for repairs, insurances, indemnification, leasehold improvements, options to renew, notices, termination of leases are explicit. And they should also be discussed before the contract is executed. In the absence of express terms and condition of the usual covenants, there are implied covenants for quiet enjoyment, which allows the tenant to recover damages from the landlord if the person to whom the covenant extends physically and substantially interfere with the tenant's enjoyment of the demised premises. So once you enter into a lease, remember, it says that you have the right to exclusive possession. And that exclusive possession means that you have quiet enjoyment. And quiet enjoyment means that the landlord cannot keep knocking on your door, entering your apartment, saying that he's coming to check on items or he's coming to see how you are doing. That's what quiet enjoyment means. So in addition to the implied covenant of quiet enjoyment, a landlord has an obligation not to derogate from his grants to the demised premises. So that means he has to make sure that the premises are always in fit and good repair. The tenant has an obligation, obviously, to pay rent and to pay rent on time. They have to pay any rates and any assessments. Another thing the tenant has to do is not to commit waste and allow the landlord to view the premises to make repairs, not to disturb the quiet enjoyment, but to make repairs. Unless there is some express conditions that stipulates when the landlord can enter into the property. But normally in a lease, the tenant has that right of exclusive possession and he has an implied covenant of quiet enjoyment. Any questions?
No, ma'am.
No, none? Okay, so I'm gonna send you some more cases. We have 3 assignments. I will take one of the new ones and I will do a slide and I will send it to you so you can see what I'm looking for. And then you can prepare yours in a similar vein, if you wish to. How that sounds? Good?
So we have to do our case studies in a PowerPoint presentation?
No, you don't have to, no.
Oh, okay.
I'm just saying, the one that I will do, I will tell you, this is the one that I did. You'll see it in the documents you receive, and then I will show you how I summarized it.
And so when we summarize our cases, we are just telling you all the whole story, painting the story of what happened in the case.
Ending the story, yeah.
Okay.
Just how we did, we went through the one with the husband, Mr. Pratt, and the son, and how he wanted full interest. And try to break it down as simple as you can so that everybody understands. So next class, we're going to look at chapter 3, which is on different types of mortgages. All right, so 3 persons already have their cases assigned. And then I'm gonna send some more on agreements for sale. I'll see what I can find on agreement for sale. Okay?
Okay.
Yes,
Hi.
ma'am.
Have a good evening.
Thank you, you too.
It was a good class, eh?
Yes.
Yes.
Good evening, everyone.
Good evening,
And good
everybody.
evening.
Now, go ahead. All right.